Hi, I'm Jonathan Kappy.
Hi, and I'm Sydney Osmar.
Welcome to Holland Estates. You're listening to episode number 618. Today, we are going to be discussing the decision of Virey and Virey. How you doing, Sydney?
I'm good. How are you? Are you enjoying the summer?
I am. It's been a lot of rain, a lot of humidity, but at least we're outside a little bit.
Yeah, exactly. We can get out of our houses.
Came to the office today, so
How exciting.
my big day trip. So today we're going to be discussing a recent decision of Justice Dietrich of Virey and Virey. It's a dependent support claim with a bit of a twist. So Sydney, why don't you start with giving us a little bit of the background?
For sure. So in this file, the applicant was a 94-year-old woman. She had been married to the deceased for 42 years. They had had 9 children together, but they had actually divorced in 1994. The deceased died in December of 2018, but the couple had, as part of their divorce, reached minutes of settlement, which was then converted to a divorce judgment. And between the minutes of settlement and the divorce judgment, certain provision was made for the spouse and for one of their dependent children. But part of the minutes of settlement, the parties released each other from any entitlements or claims pursuant to the Family Law Act, the Divorce Act, common law, or otherwise. So the court had to look at in this case was whether the estate was going to have an ongoing obligation to support the applicant, or if the applicant had actually released any entitlements pursuant to the minutes of settlement. So in kind of going through this analysis, the court looked at the general factors that they look at under the Succession Law Reform Act. So things like the length of the marriage, whether the dependent spouse had given up a career, whether they were the primary caregiver, and then obviously looking at the respective incomes, which the court did do in this case, but they also obviously talked about, moral and legal obligations that are separate and apart from what you would normally consider in a payor, payee spousal support scenario. And then the little twist is the minutes of settlement and the release that the parties had. So the court looked specifically at section 63.4 of the Succession Law Reform Act, which sets out that a court can make an award for support despite any agreement to the contrary. And in this case, that I guess would be the minutes of settlement and the divorce judgment.
Right. So interestingly enough, the court said that in the minutes themselves and the release, there was no specific reference to the Succession Law Reform Act and sort of afterlife rights. But reading her decision, I'm not sure it really became important. It didn't really matter, I don't think.
It's curious, like you say, that particular note was made, but in the analysis, I'm not sure how much of a difference it would have made if the Succession Law Reform Act had been specifically referred to. Especially, the court looked to the decision buts and quoted the court in that decision where they kind of talked about section 63.4 and how it gives the court the broad judicial discretion to award support to a dependent and holding that language couldn't be any clearer and that the purpose it was obviously aimed at achieving justice and equity. And the court did sort of focus on that in this decision as well and found that it would be more equitable if the estate did have to support the dependent spouse of 94 years old.
Yeah, I think this is a balancing act like everything else is. When we're talking about support, we're balancing testamentary freedom of a person to make a will and leave their assets to whom they want versus an obligation to support dependents. Here we're talking about something a little bit different, which is an obligation to support dependents versus contractual freedom.
Right.
We're talking about a settlement agreement, a separation agreement that was negotiated. The terms were agreed upon based upon the terms that were within the 4 corners of that document.
Right.
Certainly I would have expected that if this deceased had known that there was going to be an ongoing obligation to pay, maybe the terms would have been different. They're not around anymore to fight that, but it does create some uncertainty with respect to the contracts you're entering into. And I think that's part of the problem. There may be ways to draft around it. I don't know whether or not, that would have the same fate as the provision itself, but you can try to draft around it. But I think that's a big problem. I mean, that people are entering into contracts that are subject to change. Clearly this person created this agreement, wanted to ensure that when they died, they could leave the balance of their assets to whom they chose. And the court is saying, notwithstanding that agreement, we're still going to look after your dependents. And there's certainly a merit to that, and it appears to be within the four corners of the legislation. Absolutely, I agree with the court in Butts, but it's a tough balancing act for the court and the legislature to deal with, because there are people that need your help, that are your dependents, but at the same time, they want to give you your right to deal with your assets as you please. It's a tough one.
It is, and it's interesting. Like the agreement being subject to change. And in this case, the court actually looked at some of the reasoning in previous decisions and noted that the divorce judgment in the minutes of settlement were entered into in 1994. And the court looked at the societal values at that time versus today. And so they held that, back in 1994, it was more commonly accepted that, the divorcing spouses, whoever was the dependent of the two, would be supported, and that would be it. They would get spousal maintenance and that was it. Where today it's more accepted that on marriage breakdown, they should be entitled to a share of each other's estate and not just your base minimum support. So that kind of fed into the decision as well, which was sort of interesting kind of color and context to how section 63.4 was used.
Yeah, I got the feeling that, when she was describing that circumstance, that she felt as though had the spouse moved to vary the settlement and increase the support, that she felt as though she would have been successful, and therefore lived since 1994 for 30 years, getting undervalue on her spousal support, and in many ways tried to fix that as well.
Yeah, I mean, and it's interesting because in the minutes of settlement, the release and in the divorce judgment as well, it actually specifically set out that the spousal support wasn't subject, like it couldn't be varied. So it's interesting that the court felt that she would have succeeded. And obviously when you get into trying to vary in order, you would have to prove a change in circumstances. So there must have been something there to make the court think that she would have been successful in that. But yeah, it's
well, it may be that the court didn't have jurisdiction until the court could use 63.4.
Yeah, that's also a good point.
I mean, we're not family lawyers. We don't know how
yeah.
of matrimonial agreements work, but it may be that she had to wait for this provision to take hold.
Yeah, it could be.
So, but an interesting decision, and really, it's never over. It's not the court and the legislature just give so much power to a dependent to ensure that they're taken care of.
Yeah.
And when you're a dependent, you need someone to look after you. That's what a dependent means.
Yeah, exactly.
So the court treats them that way. So it's an interesting case, and it came up in the late 90s in Butts, and now it's back again.
Yeah, it's back in full force. And in this case, the dependent actually, so leading up to death, she was receiving about $800 a month, and the court awarded her over $3,000 until her date of death. So to your point that, the court thought she might have been successful in varying the agreement, I think that's reflected in the quantum that they ultimately gave her. I think it also reflects her age, since she was 94. But yeah, it's interesting. It's like you mentioned before with you need the certainty in contractual agreements, but you're balancing dependent spouses and children and those who need support and that may not have been adequately provided for. So we'll see if more cases like this come up.
All right. Well, I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Sydney Osmar.
Should you have any questions, please email us at info@hullandhull.com or leave a comment on our blog. Have a great day.
Thanks. Take care.